Hello, and welcome, and thank you for joining today's webinar titled Know Your Rights and Options, a webinar for community college and adult school students. Before we begin, I'll go over some housekeeping rules. All listeners are on mute. If you have a question, please enter it in the question box which appears on your screen. Please also use the question box to let us know if you're experiencing any technical difficulties. This webinar will be recorded, and we will share a link with you all via email after the webinar. Feel free to share the link with others who may be interested and couldn't join today's webinar. So why are we having this webinar today? Well, things have definitely changed since Trump took office. There have been executive orders issued by the new administration related to immigration and enforcement. We unfortunately don't have time to go over them today, but we encourage you to visit our website, www.nilc.org, to find out about them. There have also been various reports in the media of ICE operatives in certain areas arresting and detaining people. Lastly, the combination of ramped up enforcement and the uncertainty of what's to happen with DACA makes it harder for students to plan for their future. As of now, it's rumored that the administration is conflicted about what to do with DACA, so until we get confirmation that DACA will remain in place, it's important to plan for all possible scenarios, including the scenario where DACA is rescinded. So today's webinar is specifically for adult school students and community college students in California who have DACA or are undocumented. We've seen really great work being done in various districts and colleges, passing resolutions to create a safe space for students and hosting events like town halls and Know Your Rights trainings. But we wanted to provide some information now for those who perhaps can't attend such events due to school, family, work obligations, etc. So here on your screen, you can see exactly what we will be going over today. We will be first talking about Know Your Rights. Then Jess Hansen's going to talk to us about safe zones and creating sanctuary policies. Then I'm going to speak about information to keep in mind if you're planning to continue your education. And lastly, Josh Selleck will be providing us with information if you're planning to join the workforce. So we'll begin with a Know Your Rights presentation by me, Ignacio Rodriguez, Immigration Policy Advocate at the National Immigration Law Center. So what to do if you're questioned by the police or ICE? It's important for you to know first and foremost that everyone in the United States, whether they be undocumented or have papers, they still have legal rights in the United States. And so today we're going to talk about the specific scenario where, let's say, the person is stopped on their way to and from school or to and from work, in the street. We also have information on our website, www.nilc.org, about what to do if ICE comes to your home, but due to time limitations, we will focus on the scenario in which ICE comes up to you on the street. So you have the right to ask an officer if you are being arrested or detained. If the officer says no, you are not being arrested or detained, you can ask the officer if you can leave. If the officer says you can leave, make sure you do so calmly. If the officer says, yes, you are being arrested or detained or something along those lines, you have two very important rights. You have the right to remain silent, and you also have the right to speak to an attorney, which you can exercise at that point. So what does it mean to have the right to remain silent? You do not have to answer questions about your legal status, where you were born, or how you came into the United States. You can tell the officer that you have the right to remain silent and you wish to exercise it, or you can go ahead and show them the Know Your Rights card. Here on our screen we have an example of one, but our partners IRC also have some red cards that you can show. In some states, you do have to state your name, but fortunately in California, you don't have to give an officer your name. If you choose to provide information, if you choose not to remain silent, it's important for you not to give any false information and to not lie. The second right is the right to an attorney. So you have the right to talk to an attorney before answering any questions. Again, you can tell the officer that you want to talk to your attorney first, or you can show your Know Your Rights card, which has this information. A couple of important points. One is sometimes when ICE approaches people, they may have a warrant. It's important for you to look at the warrant carefully and make sure it states your name, address, and that it actually has a signature from a judge. Sometimes there's confusion because what ICE will present instead is a warrant that's signed by someone within the agency, within the Department of Homeland Security. So on your screen, you have a sample of what a warrant signed by a judge looks like. Usually at the top, there's a heading that includes the word court, and you'll see that the signature is usually by a judge. That would be a valid warrant for your arrest. However, sometimes the document that ICE officers present is actually not signed by a judge, but it's signed by someone within their agency. And so you'll be able to distinguish between the two by looking at the headings at the top. For example, the one on your screen states that it's from the Department of Justice, or it'll say the Department of Homeland Security, but it won't state that it's from a judge. And so it's important to draw that distinction because at that point, they really don't have a valid warrant for your arrest. Also important, don't sign any documents. You do not have to sign any papers that you do not understand. It's best to wait until you speak to an attorney. And also, do not let someone pressure you into signing any papers. If you don't know what you're signing, if you don't know what the document is stating, it's best just not to sign it and to ask to speak to an attorney. And lastly, we wanted to share some information regarding certain documents that you may or may not have. If you have valid immigration documents, you may show them if you wish to. Again, we want you to ideally exercise your rights to remain silent and to speak to an attorney first if you're approached by ICE. But if you wish to engage, you may show them the documents that you have. However, you have to be very careful of which documents you can carry. So for example, if you are a green card holder, if you are a legal permanent resident, by federal law, you're supposed to carry around your green card. Some people who have employment authorization cards, commonly people who have DACA have these. Before, folks were advised to leave them at home just to be safe. Now some people are choosing to carry it around, or at least a copy of their work permit, of their EAD, just in case. Still, do not carry papers from another country. So that includes a passport or a consular ID, also known as a matricula. It's best for you not to carry these documents with you because it can be used against you in the deportation process. So an officer who sees these documents is allowed to then presume that you may be a foreign national, and then unfortunately that would be a red flag. And so it's best, if you have those documents, to leave them in a safe place at home and not carry them around. And that's, again, if it's a foreign passport or a consular ID from a consulate. And now Jessica Hansen will speak to us about safe zones and sanctuary policies.
Thanks, Ignacia. So today I wanted to go over with you all, first, the components of sanctuary policies that we have seen several schools, both K through 12 districts, which include adult schools, and also college systems or individual colleges adopt. So we'll go over the components of that so that you understand them, so that you can then, if you wish, advocate for your school to adopt similar policies. And second, we'll go over how to encourage your school or district to adopt a resolution. So one component of sanctuary policies is pointing out that there's a sensitive locations memo that DHS published in 2011, and which we understand, despite some recent actions, that it is still in place. It's a policy document that outlines how and to what extent ICE, or Immigration and Customs Enforcement, can engage in enforcement actions in sensitive locations, which includes schools. That means they're not supposed to do any sort of immigration-related arrests in or near these places. There are some exceptions, which include if someone poses, quote, an imminent threat or a national security risk, if the officers are pursuing a fleeing suspect and the suspect runs onto a campus, they can follow that person, or if there's a risk of destruction of property if they don't arrest a person on a campus. Another component of sanctuary policies is the Family Educational Rights and Privacy Act, or FERPA. So this act generally prohibits school districts from providing third parties, such as ICE, information about students that are contained in student records. More specifically, FERPA prohibits school districts from disclosing personally identifiable information in a student's education records to outside agencies without either parental consent if the student is under 18 or the student's consent once the student turns 18. Another way they are allowed to disclose it is if a court issues a subpoena or an official court document asking the school to give that information to the court. A student's education records includes records, files, documents, and other materials which contain information directly related to a student and are maintained by an educational agency or institution. If a school has recorded and maintained information about a student being undocumented, which is not always the case, this information will be part of the student's education records. One exception to FERPA is that the district can disclose what is called directory information without consent, unless the student opts out. And one thing we'll talk about later is the importance of opting out of this, because one piece of information that is considered directory information is country of birth. And so if ICE is trying to obtain evidence of a person's birthplace to use against that person in deportation proceedings, country of birth is something that could be prejudicial to the student. And for that reason, it's important for students to opt out of their directory information being shareable. Finally, there may also be state privacy laws. And in California, the state legislature is currently working on bills that would strengthen data protections in California even beyond what FERPA does. And so that's a possibility as well. A policy component of sanctuary policies that schools can adopt are, some examples are here of how schools can protect records. So first, and the biggest protection is, the school never collects any immigration-related information in the first place. So part of a resolution could include a provision saying the school shall not ever collect immigration-related information about any of its students. Second, the district does not inquire about a student or a family member's immigration status. Third, and this gets around what I explained earlier, the district agrees to not include place of birth in their directory information. So the school can choose to never collect that, even though under the federal law, that information would be shareable as directory information. The school can avoid that by not collecting that information at all. In addition, the school can commit to not communicate with ICE about a student's immigration status. And going back to the opt-out for directory information, the school can ensure that students know they can opt out. So perhaps a monthly or bi-monthly notice or newsletter that includes, as a reminder to students, please review this and opt out if you do not want sensitive information about your directory information to be shareable. And finally, the district or school can agree to not release any data about a student without a subpoena from a court and without legal advice from the school's legal counsel or head attorney. Another component of sanctuary policy for school is preventing physical access to the campus on behalf of ICE. So there's three bullets here. First, the school can create a process that ICE must follow in order to request access to a school site. And this is because students have rights to not be arrested without a warrant or without probable cause. And so the school can erect protections that basically ensure that ICE is not violating the Constitution when it desires to pursue a student on campus. As a part of that policy, the superintendent or general legal counsel would ask the immigration agent for that agent's credentials, why the agent wants to access the school, and to see a judicial court warrant for a specific student's arrest. And as Ignacio mentioned earlier, in order for this warrant to be valid, it must be signed by a judge. And so the superintendent or general counsel would be in a position to evaluate that warrant and see if it's actually sufficient. Another component of sanctuary school policies is campus security. As you probably know, a lot of times ICE gets to people because police help them encounter people. And so campus police is no exception. If campus security or police have a policy to not cooperate with ICE, that will increase the protection for students on campus. And so a couple things here, campus security can be prohibited from inquiring about or recording. For example, if a student blurts something out, they would not record any information regarding an individual's immigration status or related information. And campus police shall not participate in immigration enforcement efforts. And this includes campus police not holding students for ICE. If ICE asks them to detain a student for them, the campus police would not do that. Not responding to ICE notification or transfer requests. Not making any arrests based on civil immigration warrants. And not allowing ICE to use any campus facilities for immigration enforcement purposes. Another really important and the last policy component before we go into encouraging your school to adopt a policy is providing resources and information. Schools are really hubs of information, and there's a huge amount of human capital there because all the students are there, all the professors are there, and so it makes sense that schools should be encouraged to provide additional resources, information, and even help for students. Here specifically mentioning undocumented, documented, and Muslim students in this context as 3 student groups that are really being targeted right now by the administration. The school can create a resource center or information center directly serving these groups. And the school could even pay for legal representation of students and family members facing deportation. And actually the UC system is already doing this, and so it is something that schools could possibly do. Another thing that on a school campus can do that would be a source of increased resources is creating a rapid response plan for the campus itself. This means that if there's some enforcement activity happening on campus, there would be a rapid response plan to assist any students who may have been detained or whose family members have been detained as a result, as well as a plan for training teachers, administrators, and all staff of the school on how to respond to ICE personnel who may be requesting information or access. So some of these things to implement this would include a text, email, or phone tree. And this is basically a rapid response way of, for example, I communicate with these 10 people communicate each with these other 10 people so that the information is rapidly spread. You can also call Chirla's hotline to report any enforcement activity, and through calling that hotline, attorneys will be deployed to the scene to evaluate what is happening and document what is happening. So that line is on your screen. And you can also send text messages to United We Dream about enforcement activity you're seeing at a school. And if it's possible, if you're present there and it's safe to do so, you can take photos and videos and write down notes on what happened, because this is all important evidence later if the action is challenged in court. So how can you encourage your school to adopt a policy? For adult schools, it will be through a Board of Education meeting, and the Board of Education would adopt a written policy. So what you can do is present a model resolution tailored to your school to the Board of Education meeting, and you can even provide testimony about how you're experiencing being on campus in the Trump administration, why this is important to you, and encourage them to declare all schools in the district, including the adult schools, as sanctuaries. For community colleges, it depends on the college, but you would go to the school leadership, perhaps the chancellor or president, to propose a resolution, and that person would have to sign off. But in both circumstances, you can get involved by providing comments to either the board or to the leadership at your school, and having other alumni, other students, and supportive faculty also provide supportive comments. All right, finally, here are some talking points. So some people have had a hard time kind of articulating why their school should adopt this legal policy. So first and foremost, it goes without saying that students must feel safe in their learning environment to actually be able to learn. If they are afraid, they're not going to be able to focus and they're not going to be productive. A safe zone resolution would make sure that students can learn, grow, and thrive and actually be supported in completing their education. Second, on the flip side, teachers and professors cannot fulfill their mission of educating if their students are so distracted by fear. In that case, the teachers and professors, as many of you probably know, have spent a lot of class time, instead of teaching the lesson plan at hand, have spent a lot of class time supporting students and classrooms that are just racked by fear. Number three, another talking point that perhaps the Board of Education can really relate to is that we're all connected and we all live and study together in the same communities and classrooms. So anything that harms one person or two or four or five, six, 7 people is going to harm all of us, and it's going to interfere with all of our progress. Number four, the school or district can and therefore must commit material and psychological support in order for its students to thrive and really invest in its students. That's in the best interest of the school. Fifth, students have constitutional rights, and the school should ensure that any agency that is coming onto campus or requesting information about students is following constitutional rules. And finally, a safe zone resolution will ensure consistent responses on campus to immigration agents. This will ensure that faculty, staff, and teachers and other employees consistently apply the policy and know exactly what they're supposed to do if a federal or state law enforcement official contacts them or attempts to come in. This structure will make everyone feel more at ease and maximize the protections that schools can legally provide for their students. Overall, the safer and more secure that students feel, the better they will be able to learn and prepare to contribute to the country's future. It goes without saying. So here, as Ignacia mentioned, we will be distributing these slides, so you'll be actually able to click on these links when you receive them. But if you are interested in encouraging your school board or college president to adopt a resolution, here are some samples that we have created that you can then tailor to your school. So the K through 12 includes adult school language, and there's also a model resolution for colleges and universities.
Thank you, Jess. Before we continue, just a quick reminder to please use the question box on the right side of your screen to let us know if you have any questions or if you're experiencing any technical difficulties. We will do our best to answer your questions at the end. And now we'll proceed to talk about information to keep in mind if you're planning to continue your education. So if you notice in the past couple of years, whenever there's a proposed or actually enacted immigration relief, there usually tends to be some kind of educational requirement involved. And so we have 3 examples here listed. As you know, DACA required either a high school diploma or state equivalent GED, or that you are in the process of attaining either one. And some vocational training programs actually qualified for you to be able to receive DACA. The Bridge Act, which has been introduced but is not law, the Bridge Act would provide people with provisional protected presence and with a work permit, so it's very similar to DACA in that sense, and it has the same requirement. So you have to either attain your high school diploma or your state equivalent such as a GED, or be in the process of attaining either one. We don't know at this time if vocational training will meet the educational requirement of the Bridge Act. And then the DREAM Act, which has been proposed at the federal level time and time again, the last version of the DREAM Act required either a high school diploma or a state equivalent, such as the GED, plus 2 years in college working on a bachelor's degree or a higher degree than that. And so if you notice, it's best for you to continue to stay in school, if possible, to attain higher education, because we don't know what options will be available in the future, but there seems to be a pattern where some of the immigration relief that has been proposed does have an educational requirement to it. But still, it's important to plan for all the possible scenarios. And so if you're interested in learning more about the California GED exam, we provided a link here, which again will be available for you after the webinar, so you can find out more information. It's important to note, based on the inquiries our office has received, that if you're planning to take the GED or any other admissions exam, such as the LSAT or the GRE, just make sure that whatever document you present to prove your identity will be accepted by the testing service, and that the name that you register with to take the test matches exactly how your name appears on that ID. So for example, if your ID, your current foreign passport, has 2 last names, make sure that when you register for the exam, you actually include both of those last names as part of your full name. And that's because when there's discrepancies, that unfortunately has led to confusion and for some people to not be allowed to take the exam. So just try to take care of that before testing day. And so we're going to talk about AB 540. So to qualify for AB 540, well, first of all, before we get into requirements, why would someone apply for AB 540? What are the benefits? Well, there's many. First, you get to pay the same tuition as residents of California, so you don't have to pay out-of-state fees if you qualify for AB 540. You can also qualify for the California DREAM Act, and that allows you to receive certain forms of state aid and institutional aid. And then you can possibly qualify for a DREAM loan, depending on what school you attend. So, for example, UC Berkeley does have a loan program that you can qualify for if you qualify for AB 540. And so how exactly do you qualify for AB 540? Well, what it does is it allows you to be exempt from non-resident tuition, again, not to have to pay out-of-state fees, as long as you can prove these requirements. Graduating from a California high school or attaining a high school equivalent certificate, such as the GED, and then also resulting from the California High School Proficiency Exam is also an option. And then registering or being currently enrolled at an accredited institution of public higher education in California. So you must be admitted by a school in California. Filing an affidavit with the school saying that they will apply for legal residency as soon as possible. And this is basically a document that is only seen by you and the school. They're not allowed by law to share it externally. The issue with AB 540 that sometimes it makes it harder for people, specifically those who are in adult school programs, to meet the requirements, is meeting the number of years in a California school requirement. So you can either fulfill this requirement if you've attained a high school diploma and you've also gone to high school in California for 3 or more years, or you obtained your GED, but you attended a school in California for 3 or more years. And as of a couple of years ago, you can actually also qualify for AB 540 if you've obtained essentially the number of credits that you would get in a 3 years of high school, but in less time. As long as you can also prove that you've been in the California K through 12 school for at least 3 or more years. Unfortunately, and this is why I mentioned it makes it harder for adult school program students to meet these requirements. Unfortunately, attendance in a California adult school program does not count towards the 3-year requirement, so you must have gone to high school in California for at least 3 years, or you might meet the second requirement listed on your screen. But the number of years that you're in an adult school program in California, unfortunately, do not count. Also important to note, AB 540 students must not hold a valid non-immigrant visa. So for example, F1 students would not be eligible for AB 540. T visa holders, U visa holders, and DACA recipients can apply for AB 540. So before we proceed, I do want to recognize that AB 540 is not available to all students, yet still AB 540 students have for decades now been able to go to college and pay out-of-state fees. It may require sacrifice, like for example, taking semesters or quarters off to raise the money for tuition, but it's definitely possible. I also want to note that if you look at the AB 540 requirements, nowhere does it state that you must have DACA. It is not a requirement at all to qualify for AB 540 and then to qualify for the California DREAM Act or for a DREAM loan if your school provides it, meaning that if something were to happen with DACA, you would still have these options in California. And now we'll hear from our last presenter, Josh Selleck, who will talk to us about information to keep in mind if you're planning to join the workforce.
Thanks, Ignacia. And so, as Ignacia mentioned, we're going to shift focus a little bit and drill down on some issues that would really apply if an individual is planning to join the workforce. I'm going to cover individual taxpayer identification numbers. I'm going to touch on the availability of occupational and professional licenses to immigrants in California specifically, and then very briefly touch on the Workforce Innovation and Opportunity Act, or WEOA. So I'm going to start with individual taxpayer identification numbers, or typically referred to as ITINs for short. An ITIN is an individual taxpayer identification number. It's a unique numerical identifier that the IRS created in 1996 to promote tax law compliance, and it's available to taxpayers who are not eligible to obtain Social Security numbers. So this would certainly include individuals who are here undocumented or without lawful permission, but it would also include certain categories of lawfully present individuals and certain U.S. resident aliens or non-resident aliens. So the fact that somebody has an ITIN in and of itself does not tell you that they are undocumented, because there are, as I mentioned, several categories of individuals who are lawfully present in the U.S. but who aren't eligible to obtain a Social Security number but still have a tax filing obligation. In terms of applying for an ITIN, it used to be easier. It's become increasingly more difficult, or the rules have increasingly tightened over the years, including recently at the end of 2015, a requirement that certain ITIN holders have to reapply after a certain amount of time. But basically, the individual who's applying for an ITIN files the IRS Form W7 along with the federal income tax return for which an ITIN is sought. So somebody can't simply file a standalone application for an ITIN. They have to file it along with the tax return. It takes about 6 to 8 weeks. This varies a little bit depending on the time of the year, and it has slowed down in recent years overall. But it takes generally at least 8 weeks for processing time to obtain an ITIN. And the person must include original or certified documents that prove both their foreign status and their identity. And the instructions for the Form W7 list out the documents that are acceptable for these purposes, and I've listed some of those out on the screen there. And I did want to note, notarized copies are not allowed, so the person has to mail in their original or certified documents, which can be difficult for some immigrants for whom that may be their only form of identification. If that's the case, there are some taxpayer assistance centers which are operated by the IRS, and you can find them located by state on the IRS website, that do allow people to walk in and submit an ITIN application and show their supporting documentation without the Taxpayer Assistance Center then having to retain that documentation. So that is a workaround for individuals who can't or who are uneasy about submitting their original documentation by mail, although IRS will mail those documents back, but that can take time, and in the interim, someone may be left without any form of identification. So taxpayer identification centers are an alternative. Not all of them will process ITIN applications, but it does spell out on the IRS website what the Taxpayer Assistance Center can handle and whether it processes ITINs, and it also contains a phone number for each center, so the individual could call ahead to make sure that the Taxpayer Assistance Center that they are seeking assistance from will be able to assist them with an ITIN application. I did want to flag in terms of the ITIN that in general, Social Security number holders and ITIN holders are subject to the same rules, the same deductions, and the same tax credits. But there are some exceptions, particularly with regard to refundable tax credits. Welfare reform in the late 90s, for example, amended the earned income tax credit, which is available to certain taxpayers generally who have who are low income and have basically made ITIN holders ineligible for the EITC or the earned income tax credit. You have to have a Social Security number, the tax filer does, and any dependents that are being claimed also have to have a Social Security number to claim the earned income tax credit. However, ITIN holders are still eligible for the child tax credit and the additional child tax credit. There are numerous benefits to having an ITIN. I mean, first and foremost, it facilitates tax compliance and whether someone is in the country lawfully or not. If they meet the earnings threshold for their tax filing status for that year, they are obligated under federal law to file a tax return. And so it does ensure that workers report income and pay taxes. And you can see there that ITIN holders contribute significantly to the federal fisc. As of 2010, there were approximately 3 million ITIN holders, and ITIN holders pay over $9 billion in annual payroll taxes and close to $1 billion in federal income tax in a given year. As I already mentioned, another benefit of the ITIN is to claim and receive earned tax benefits, including the child tax credit and the additional child tax credit. And then finally, it can be helpful in the immigration adjustment of status process for somebody to be able to show that they've complied with the tax laws while they were present in the U.S. So that those tax returns can demonstrate good moral character. They can also evidence work history and physical presence in the U.S., which can be an issue when somebody is attempting to adjust their immigration status. In terms of challenges, I did just want to flag that there is every year a fight in Congress or a threat to potentially limit the eligibility for the child tax credit and the additional child tax credit by excluding ITIN holders and their dependents and requiring a Social Security number for those credits, as has been required for the EITC since the late 90s. Thus far, those attempts in Congress to restrict eligibility have not been successful. We would expect under the new administration to see those sorts of threats resumed. And in fact, there is a draft executive order that has not been issued by the President. It's just been leaked to the press in draft form that would restrict eligibility for the child tax credit to Social Security number holders only. We've gotten a lot of calls since the election about potential risks of filing a return with an ITIN or applying for an ITIN, and the concern is really whether sharing your individual personal information with IRS might expose you to immigration enforcement as a consequence. Current law, which is encapsulated at the Internal Revenue Code section 6103, provides very strict confidentiality provisions for tax filing information and data that's held by the IRS. So in general, information that's provided to the IRS is confidential. There are some enumerated exceptions within IRC section 6103, such as if the information is subject to a court order. But in general, and historically, current law provides robust confidentiality protections, and the IRS institutionally has been very invested in maintaining those confidentiality protections because they know that if confidentiality is breached, that will result in a chilling effect and a reduction in the number of ITIN holders who file income tax returns. So it is possible that Congress or the Trump administration could attempt to make changes to existing law, but we haven't seen anything along those lines introduced, and I think there would be quite heavy pushback if Congress attempted to relax the confidentiality protections within the IRS, both not by Democrats, by immigrant rights organizations, and likely by the IRS itself. So if someone already has an ITIN, the IRS already has their personal identifying information, and so they're not necessarily increasing their exposure by renewing their ITIN or by filing a tax return with an ITIN unless they've recently changed their address. And again, as I noted before, not all ITIN filers are undocumented, so the mere fact that someone has filed a tax return with an ITIN does not confirm or reveal their immigration status. All right, I'm already coming upon my time, so I'm going to move a little bit more quickly, but I did want to touch on immigrant eligibility for occupational licenses within California. I did want to note at the outset that occupational licenses or certifications are often required not only for professional jobs like attorneys or physicians, but for a wide range of other jobs that may have much lower level entry requirements. So in California, for example, a license or a certification is required for more than 100 different jobs, including things like barber, cosmetologist, pest control applicator. So it's not only professional positions, but a range of other types of jobs within the state that do require a license or a certification. There is a federal law that deems professional licenses to be a state or local public benefit, and that essentially sets a default rule that only qualified aliens, quote unquote, are eligible for professional licenses. And I would note that qualified aliens is not defined to include the entire universe of individuals with lawful presence in the U.S. So the way the statute defines qualified aliens does not include individuals with deferred action, for example. However, federal law does allow states to expand immigrant eligibility beyond that default that's set by federal law if the state passes a law after August of 1996, affirmatively expanding immigrant eligibility, and that is exactly what California did. So California passed SB 1159, I believe it's about 2 years ago now, and that provides for eligibility for professional or occupational licenses in California regardless of immigration status. It allows individuals to provide an ITIN in lieu of a Social Security number, and it is the only law of its kind in the U.S. So there are other states that have expanded eligibility for immigrants to professional or occupational licenses within that state, but none have done so to the extent that California has. So that really is a landmark bill. And then finally, I'm just going to touch very briefly on WIOA. Many folks on the phone are probably quite familiar with WIOA. It's the Workforce Innovation and Opportunity Act that passed back in 2014 with overwhelming bipartisan support in both houses of Congress. And it reauthorizes and essentially replaces what used to be the Workforce Investment Act, or WIA. So we've gone from WIA to WIOA. And it is the key piece of federal legislation that provides for workforce development and adult education and skills training across the country. And so I just wanted to quickly touch on the fact that under WIOA there are two titles. Title I, which applies to workforce and job training services, and then Title II, which applies to adult basic education, adult secondary education, and also integrated English literacy and civics education, or IELCE, within WIOA speak. And one of the primary differences that I wanted to highlight is that folks who receive services, workforce or job training services under Title I must be work authorized, and that does include individuals who have DACA, whereas folks who receive adult ed services, including basic ed or adult secondary education under Title II, there is no work authorization or immigration status requirement for Title II services. And I think that brings us to the end of the presentation section of our webinar.
Great, thank you, Josh. Before we begin answering questions, a quick reminder that this webinar is being recorded and a link will be shared via email, most likely early next week. So we'll go ahead and proceed to the Q&A, but here listed are our email addresses, so feel free to reach out if for whatever reason you don't get to your question or if questions come to mind later on. So just first, I'm going to provide some clarifications. Thank you for those who submitted these inquiries. The first question was, what kind of ID should someone carry? That's basically up to the individual. If they have a state ID or a driver's license, then they may go ahead and carry that. Under federal law, if you have a green card, you're supposed to carry it with you. And then some people with DACA or with other statuses that receive a work permit, an employment authorization document, some people choose to carry it, but they also fear, you know, what if it were to get lost and they would have to pay the full fee to get it replaced. So others choose to leave it in a safe place, but others do choose to carry around a copy of the document just in case. Also, there are questions around where to actually obtain Know Your Rights cards. So if you go to our website, www.nilc.org, you'll see our Know Your Rights handout, which has a cutout of a Know Your Rights card. You can also go to ILRC's website to be able to order actual physical cards from them. But after this webinar, when we send the recording, we'll send specific links to where you can find those both on NILC's website and on ILRC's website. Also, there were questions about meeting the educational requirements for the DREAM Act, whether an associate's degree counts. There is no DREAM Act being proposed. It was just an example to show how past proposed bills and past immigration relief options tend to have this running theme of having an educational component to them. If the DREAM Act were to be reintroduced, we don't know what the educational requirements would be or if it would contain any, but nothing has been proposed thus far. Okay, and so Jeff, the first question we'll go ahead and pose for you. Let's scroll up, sorry. Please give us one moment as I read through it. So in the adult school setting, sometimes there's not someone on campus that could be able to, for example, evaluate the validity of a warrant. What can people do? How does an administrator know whether or not ICE is coming to seek a specific person or if the warrant is valid?
Great question. So a couple different points. And first of all, I would say that part of the purpose of having a school or district-wide resolution and training on that for everyone who works in the school is that all teachers, professors, faculty, and other employees would be aware of this policy and know that if an ICE agent shows up, they would tell the ICE agent, I'm referring you to someone else, either our legal counsel or a top administrator to review this warrant. I would say though on another, and if, for example, if you're in an adult school that is part of the LAUSD system, they have a division of adult and career education that could possibly, you could possibly reach out to talk about this issue. For example, if the issue is that there's no staff on campus at night, that's something that in the individual context you could advocate for change. And my other point is this question is a great example of concerns that you could bring up at a Board of Education meeting and say, you know, at maybe the LAUSD does have a resolution in place, but it's more directed for K through 12 schools in the district. So you could go to a Board of Education meeting and bring up that concern that you would also like to see the resolution consider adult schools more fully, for example, staffing night staff who are specifically trained in how to respond to ICE trying to enter campus, so that even when there may be less students on campus, the students who are there still know that there's someone who will be responding to those requests.
Great. Thanks, Jess. Another question for Jess. Will undocumented students' information be guarded under FERPA for California public schools, both K through 12, and they're also asking about higher education?
Great question, and the answer is yes. So FERPA covers both K through 12 and higher education for all students. If the student is under 18, then the parent controls those rights. Once the student turns 18 and thereafter, the student controls those rights. So when I was talking about opting out, if the student is 17 or younger, the parent has to do that. If the student is 18 or older, then the student can opt out, himself or herself.
Thank you, Jess. So we have a series of questions about ITINs for Josh. What is the purpose or benefit of having an ITIN?
Well, I touched on some in the presentation, but I mean, one of the primary purposes or benefits, I mean, the primary purpose or the reason the ITIN was created was because individuals who have a tax filing obligation in the U.S., whether they're here lawfully or not, are required to comply with that tax obligation. So if someone earns income, for example, above the income filing threshold for their tax filing status that year, they're obligated to file a tax return under federal law, whether they're undocumented or not. So that's the reason the IRS created the number. But there are also additional benefits that accrue to individuals who have an ITIN, including in the immigration adjustment of status process. So if somebody formerly undocumented or has then a basis to adjust or change their immigration status, oftentimes having a paper trail of tax filings can be helpful in that process, both to demonstrate good moral character and to show that they were complying with their tax obligations while they were here in the U.S. It can also prove things like physical presence in the U.S. and work history if that's relevant to their particular application. So, so both for tax compliance reasons, but also for other reasons. And in some places, an ITIN can be used, for example, to open a bank account. So there are some sort of secondary benefits beyond just tax compliance or benefits in the immigration adjustment process that accrue to the ITIN.
Great, thank you, Josh. And then another question is, when applying for an I-10, do people need to submit their original birth certificate, etc.? Will they be returned, these documents?
Yes, yes, the IRS does return. You do have to submit original documentation or certified copies proving both your foreign status and your identity, and those typically then would be submitted by mail to the IRS as part of the I-10 application process. If someone's uneasy about submitting that documentation directly or doesn't want to forego having that documentation in hand for the period of time that it would be pending with the IRS, then they could go to an IRS-operated taxpayer assistance center that assists with I-10s and have their I-10 application prepared there and show their documents to the IRS staff at the Taxpayer Assistance Center.
Another question for Josh. If someone wants to claim their child for the child tax credit, does the child need a Social Security number? Can they have an I-10?
The child can also have an I-10 or a Social Security number. So there's not a Social Security number requirement for the child tax credit, either for the taxpayer or for his or her dependents.
Great. And then we have a couple of questions wanting to clarify the information on AB 540. So AB 540 was passed in 2001, and then a couple years ago they passed AB 2000, which expands the number of people who could qualify for AB 540. So in order for you at a public university, we're not talking about private schools, private colleges, to be able to qualify for AB 540 and pay the same tuition as everyone else, you have to have either attended school in California for 3 or more years, or you can also qualify having attained the number of credits that would be equivalent to 3 or more years of high school, but in a shorter time span. And additionally, you have to show that you spent 3 or more years at a California elementary school, middle school, or high school, or a combination of those 3 types of schools. So it's only K through 12. And so an adult school student can still qualify for AB 540 by meeting either of those two requirements and getting their high school diploma or equivalent. The only thing is to meet the number of years that you've been in school. The time that you've been in an adult school program in California don't count to meet that requirement. And I know that's rather confusing, but what we'll do in the materials that we sent out, we'll include links to these specific laws so you can then see if it's an option for you. And then there were questions around, well, if someone doesn't meet AB 540 and they want to pursue higher education, what advice would you give? What are their options? Well, the reality is, as I mentioned, that there's plenty of people who don't qualify for AB 540 now. AB 540 itself didn't come into fruition until 2001, and there were plenty of people going to college before then. As I mentioned, it takes a lot of sacrifice. It takes a lot of finding a support group on campus, being able to be flexible, right? Some semesters you may be able to be in school, others you may have to take off. So it's more challenging, but it's definitely doable, and I encourage you to look up the La DCIA network, which did a lot of the work in helping students before AB 540 was enacted. And then another option is to look into private colleges. Private colleges have more flexibility. They don't have the same constraints that public colleges do when it comes to providing assistance to their students. There were also some questions around why are we mentioning the GED, why aren't we talking about HISTAT or the TAC. We'll send links that will provide you with more information on these exams, but the majority of the cases we've seen of people who have applied for DACA have been either having gotten their high school diploma or gotten their GED or in the process of getting either one. But you could look at the exact requirements of whatever immigration relief you're seeking or whatever immigration relief is proposed in the future to see if these exams would fit that criteria. So with that, we are all out of time. I really want to thank all the speakers, Jess and Josh, for taking the time to be with us today, and also Nina, who provided all of our technical support. And I really want to thank all of you who joined today. It was really rewarding and wonderful to see how many students, counselors, professors, and school staff members shared the link to this webinar and helped spread the word. You have our contact info. Please do not hesitate to contact us. Let us know if you have any questions or any suggestions. Thank you.